Apply Section C to order. We are meeting today to continue consideration of the estimates of the Ministry of Environment and Climate Change Strategy. I will now recognize the Minister to move the vote.
Thank you, Chair. Resolved that a sum not exceeding $250,105,000 be granted to Her Majesty to defray the expenses of the Ministry of Environment and Climate Change Strategy Ministry operations to 31st March 2022.
Thank you, Minister. I now recognize the member for Abbotsford West.
Thank you, Madam Chair, and to the Minister and his officials. I wanted to take a little bit of time, and I'm not sure how long this will take, and I may impose myself upon the committee a little bit later in the proceedings on another matter. But I wanted to ask a few questions today about an issue that began before the Minister assumed his ministerial duties in this ministry in 2017, but has very much continued since that time, and it involves the saga of one of the employees within the ministry. And when I say the name Bryce Cassavant, I expect that will trigger some awareness on the part of the Minister and the staff. And I will begin merely by asking for confirmation of some rudimentary facts around what I will call the Cassavant situation. Mr. Cassavant, as I understand, was hired as an officer, a conservation officer, and in, I believe it was 2015, there was an incident that attracted some public attention, some media attention involving Mr. Cassavant and the discharge of his duties in the Port Hardy area, a call regarding a bear and 2 cubs that led to the killing of the mother bear and the relocation of the 2 cubs. That provoked, as I understand it, disciplinary action that then provoked a whole bunch of other proceedings, both before the Labour Board and ultimately in the courts. So maybe I will stop there and merely ask for the Minister to confirm that he is familiar with the situation, the circumstance that I have described so far.
Minister?
Thank you, Chair, and thank you to the member for the question. I want to say two things. One, I am familiar with the circumstance, but I also, and I'm sure the member will appreciate that due to previous roles he's played in previous governments, that he may be straying very close to human resource discussions that will not be appropriate to discuss as part of spending estimates.
Member?
Thanks, Honourable Chair, and to the Minister. And I do want to assure the Minister that both in terms of the limitations around human resource matters or other limitations that are imposed upon ministers, I am fully aware and have no intention of straying beyond what would be appropriate questioning. And I say that because my understanding of the process that has been followed is that following reference to the Labour Board, then judicial review before the Supreme Court of British Columbia, and we can certainly discuss the various findings that occurred in those public forums, that the matter ultimately ended up in the BC Court of Appeal, where a decision was rendered that the Crown sought to appeal to the Supreme Court of Canada, and leave to appeal was denied. So what we have is a decision of the Court of Appeal that following the Supreme Court of Canada decision not to grant leave to appeal represents the definitive statement on the matters involved, and it is that decision, now the definitive decision, that very public decision, that forms the basis of the questions going forward. But I do want to ensure that the Minister understands that does form the basis for the questions I want to ask, and I also want to ensure that my very quick summary of the matter and its history through the Labour Board, through judicial review, and to the now definitive decision from the Court of Appeal is also his understanding of what took place.
Minister?
Thank you, Chair. It is my understanding.
Member?
So the situation takes place, and there is the individual, Mr. Cassavant, following a decision that he made not to euthanize the two bear cubs. He was disciplined and ultimately dismissed from his position as a conservation officer. He chose to grieve that, and that engaged the involvement of his union. The matter ended up before the Labour Board, and the sanction imposed on the sanction was imposed, and ultimately there was the union on his behalf entered into a settlement agreement. Have I got that right? Is that what took place?
Minister.
Thank you, Chair, and thank you to the member, and to the member to the extent that I'm privy to human resource matters, which, as the member will know, ministers are not routinely directly involved in, or perhaps ever directly involved in. That is my understanding, that it was a settlement agreement. My understanding is actually based on news reports at the time.
Member.
Thanks, Honourable Chair. Maybe that's a good segue to a question that I did want to ask the Minister. As Minister of Environment, did he ever have specific conversations with representatives of the BCGEU, any representatives of the BCGEU about this matter specifically?
Minister.
Thank you, Chair. I don't recall having any. Genuinely, I don't think I did.
Member.
The issue ultimately evolved when Mr. Cassavant became aware of several documents that he had not had an opportunity to review and were prejudicial to his position, and the matter ultimately ended up before the Labor Board, and Mr. Cassavant's attempts to reopen the matter and revisit the sanctions that had been imposed on him, including the dismissal from his position as a conservation officer, were unsuccessful at the Labor Board. Is that the Minister's understanding?
Minister.
Thank you, Chair. And to be perfectly honest to the member, I wasn't paying attention to whether Mr. Cassavant went to the Labour Relations Board or not. I would assume, because of my knowledge of labour relations, that if he went to the court, that he either did not go to the Labour Relations Board or was unsuccessful, but I wasn't, I have no direct or indirect knowledge of that.
Member.
Thanks, Honourable Chair. In fact, Mr. Cassavant and his union found themselves in a fairly significant disagreement about whether or not to proceed to the Labour Board, and in fact the union, the BCGEU, opted to oppose his application, which prompted Mr. Cassavant to proceed on his own and through the subsequent judicial reviews. And the issue there, as I understand it, related to the union's view that it had exclusive jurisdiction to pursue matters of this sort on behalf of employees, that its decision on such matters was final, and that Mr. Cassavant, as an employee, or in this case former conservation officer, had no independent or personal rights to pursue these matters. Is that an issue that the minister had any conversation with representatives of the BCGEU about?
Member.
The Mr. Cassavant ultimately ended up before the Supreme Court of British Columbia, seeking judicial review of the Labour Board decision, where he was again unsuccessful, and then proceeded to appeal that decision to the Court of Appeal, which heard the matter. And now we are squarely within the period of time when the minister was on task as Minister of the Environment, and the Court of Appeal rendered a decision on whether or not the judge at the BC Supreme Court employed the wrong standard of review, and whether the judge at the Supreme Court erred in declining to consider this jurisdictional issue that I've just summarized for the committee about the arguments around exclusive jurisdiction. The Court of Appeal decision was rendered in 2020, I believe. Is that a matter that was brought to the minister's attention, that decision involving a member, former member of the conservation officer?
Minister.
Thank you, Chair. I'm wondering if the member could clarify, because he outlined a series of events and then asked me a question if I was aware of a decision. I'm wondering if he can narrow it.
Member, are you able to provide some clarification?
Yes, of course. Thank you, Honourable Chair. I'm now talking about the Court of Appeal decision itself, which I'm going to suggest represents an unusual event in the life of a ministry, where an employee is challenging proceedings to the highest court in the province, an employee from within the Ministry of the Environment, around circumstances that took place within the Ministry of the Environment. Was the minister briefed on, and did he become aware of the Court of Appeal decision at the time it was rendered?
Minister.
Thank you, Chair, and to the member. I first became aware of the Court of Appeal decision through a news report. I was subsequently, shortly thereafter, informed of the decision by staff. I wouldn't call it a briefing. I was given the information. I was told that there were legal issues and human resource issues that would be pursued, and that at some point I was informed that Mr. Cassavant was being represented by a former colleague of the member, Mary Polak.
Member.
Thanks, Honorable Chair. I'm curious to know what specifically what the minister would have been told about the actual decision, and we'll discuss that in a moment. But I'm certain he will need and want, and I understand, to refresh his memory. And by the way, in asking these questions, I understand there's a lot on a minister's plate. So the fact that he would need or want to consult with his staff in no way offends me at all. I think that's perfectly understandable. But I am curious to know what the minister would have been told about the decision, which, as we're about to explore, is significant. It's significant both in terms of its impact on the ministry, certainly in the case of the individual employee who pursued this matter through to the highest court. But let's start there. I'd like to know what the minister was told about the decision itself from the Court of Appeal.
Minister.
Thank you, Chair. And to the member, as I said, it was more informational than a briefing. What I was told was largely what I already knew, that Mr. Cassavant had gone to court to establish that the Police Act applied and had precedence, and that he won his case, and that there was consideration being given as to whether or not to appeal.
Member.
Thanks, Honorable Chair. And that answer is helpful. It sounds like the minister was advised at the time that the court had found that the disciplinary proceedings against Mr. Cassavant were brought in the wrong forum entirely, and that the minister was also told that the court found that the employer, the ministry, bears some of the responsibility for that. Is that correct? Was that explained to the minister?
Minister.
Thank you, Chair. I was aware and told, as I knew from news reports, that the decision was that the forum for discipline that had been chosen was the wrong forum for discipline. With regard to other matters that the member began to probe with his questions, those are actually, I'm informed, currently before the court, so further comment by me would be inappropriate.
Thanks, Honourable Chair. Well, I think we're getting to the what I believe is the nub of the issue here. Was the minister made aware, and in fairness to the minister whom I have known for some time, and if I harbor suspicions, in fairness to him, I should articulate them. The minister is, I think, leaving the impression that the sum total of his knowledge of this derived from media reports that he received. And I do want to be clear, and I want to give the minister the opportunity himself to be clear. Is he advising the committee that in this case, where on a high-profile matter that involved a lot of publicity at the time of the original issue that gave rise to discipline, and the Court of Appeal, as the minister said, finding in favor of the employee, is the minister saying that the only information he received was a quick verbal report and what he read in the newspaper?
Minister.
Thank you, Chair, and thank you to the member for asking the question in a way that I think enables me to offer some useful clarification. I mean, certainly I'm not intending to leave the impression that the only understanding I had about the case was through media reports, although it is fair to say that I listen early in the morning to the news, and I often hear things before I have a chance to meet with staff. Staff came in to ensure that I was aware of the case and why the court had, I think why the court makes a decision is always speculation, but the basis of the basic rationale of the decision, I think both my staff and I felt that to delve directly into the human resource implications with respect to a particular employee was not appropriate for me to do, and so we didn't. But I did ask some questions of staff because there were potentially some other implications of the decision that concerned me more greatly, in the sense that it made me think how we should proceed on some initiatives that we'd been talking about and I'd been urging. For instance, with the conservation officer, generally there was a certain public appetite for more transparent oversight of the conservation officer service, perhaps some independence, not exactly like we see independent oversight of police forces, but something more than just an internal oversight, and that had been raised on more than one occasion by other people, and we'd been working on what appropriate mechanisms would be to do that. And the court decision called into question whether the avenues we were pursuing would be appropriate any longer. And so we basically the discussion was about whether and how we went back to the drawing board to do what we wanted to do and what the public expected us to do in light of that court decision.
Member?
Thanks, Honourable Chair. Well, that's helpful. I'm obliged to the Minister, and speaks to some of the broader, higher level public policy issues that derive from findings on jurisdictional issues. But the underlying point about the case and the decision at the Court of Appeal, of course, relates to this. And I'll read, this is from the final page of Madam Justice Fenlon's decision for the court. The best that can be done in these circumstances is to declare that the proceedings before the arbitrator and board were a nullity, to confirm that Mr. Cassavant's dismissal should have been addressed under the Police Act Special Provincial Constable Complaint Procedure Regulation, and to leave the parties to sort out the consequences of those declarations, if any, on the settlement agreement, end quote. The highest court in British Columbia declared the proceedings involving the discipline action a nullity. Was that communicated to the Minister?
Right. Minister.
So to the member, I can't remember the exact words that were used to communicate the essence of the decision, but I know enough about labor relations and a little bit about the law, although we're all told that a little knowledge of the law is a dangerous thing, to know that that would effectively be the meaning of the decision by what I was told and reported. So I would say that it was communicated to me. I simply can't say whether the words were quoted to me or not.
Member?
Thanks, Honourable Chair. Well, it won't surprise the Minister to know what those words meant to the individual who, I should add, on a self-represented basis, had pursued this matter through, I think, 2 Labour Board hearings, the BC Supreme Court, and the Court of Appeal. To be told by the Court of Appeal that the disciplinary procedures taken against him were a nullity. I can ask the minister now. What does that mean to the minister now?
Minister?
Thank you, Chair, and I'm not sure if the member is aware of this or not, but the interpretation of those words is one of the matters that is currently before the court, and so I will not comment further on that.
Member?
Thank you, Honourable Chair. Can the minister explain what steps the ministry took to abide by the ruling of the Court of Appeal after declaring the proceedings before the arbitrator and board a nullity? The court went on to order the parties to sort out the consequences of those declarations. What steps did the ministry take to abide by that order of the court?
Minister?
Thank you, Chair, and again, thank you to the member for the question. I was told on a couple of occasions that discussions were ongoing with respect to the court decision and implementation. As I've mentioned previously, I was told that a representative of Mr. Cassavant was the member's former colleague, Mary Polak, but this is essentially a human resource issue to be dealt with by as a human resource issue by management in the ministry, working with the Public Service Agency, which the member, as a former Minister of Finance to whom the Public Service Agency reports, will know full well.
With an eye to the clock, this will be the last question, member, ahead of lunchtime.
Thank you, Honourable Chair. Did, in a circumstance where the Court of Appeal has rendered a decision declaring disciplinary proceedings a nullity, does the minister feel there is any obligation whatsoever on the part of the ministry and the Crown to offer the individual who has secured that decision after a lengthy legal battle? Does the minister believe there is any obligation on the part of the Crown and the ministry to offer that individual his job back?
Minister.
Thank you very much, Chair. There were discussions and negotiations about implementation of the decision of the court. And again, the matter is now before the courts once more. Noting the hour, Honorable Chair, I move that the committee rise, report progress, and seek leave to sit again.
Thank you. Members, a vote is about to take place, and those participating remotely should prepare their voting cards. Members, the question is that the committee rise, report progress, and seek leave to sit again. Those in favor indicate aye.
Aye.
Those opposed indicate nay. Motion's carried. Thank you, members. This committee now stands adjourned until 1:30 p.m. this afternoon.